Hello and welcome everyone to our webinar on sexual harassment, what every business needs to know now. My name is Dickson Wu and I'm a senior lawyer in LegalVision's employment and work health and safety team. And my co-host is Eleanor Kenny, who is a lawyer in the team. Before we begin, just a couple of quick housekeeping items, just so you're aware. The first thing being that you'll receive a copy of the recording and the slides in your email after the webinar. So if you ever want to refresh yourself or remind yourself of what we've discussed today, that will be made available to you. Secondly, we will have a dedicated time at the end of the webinar for Q&A. So we'd love to receive your questions and we'll try our best to answer the ones that you submit now. And there were some pre-submitted questions as well from the registration. So we'll get to as many of those as well. And finally, we always love to get your feedback on our webinars. We're always looking to improve our webinars and make them as engaging, as useful for you as possible. So if you do have any feedback at all, there'll be an opportunity for you to share that in the form of a survey at the end as well. Now, you may have seen a poll pop up. We're going to get to that in a moment. But one more thing I wanted to flag was that for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business in relation to employment or work health and safety matters or other legal business commercial areas as well. So if you are interested in that, please leave us your contact details in that survey I mentioned at the end of the webinar. You can claim that complimentary consultation. So now we move to the poll that has hopefully popped up on your screen. We're just interested to know, before we get into the actual content, what do you most want to learn about this topic, about preventing sexual harassment in the workplace? In a sense, why are you here? What are you looking for? What would be helpful? So there are some options in there for you. What constitutes sexual harassment? What are my work health and safety obligations in relation to sexual harassment? Some compliance tips, law changes, maybe it's all of the above, or maybe it's something else. Maybe you're not sure and you're just here to learn. So for the next minute or so, would love for you to be able to just answer that question with the one that's most relevant to you, and then we'll share our findings afterwards. So we'll pause about a minute or so for you to do that. Right. Excellent. So it looks like the answer that's been picked the most is all of the above. So that's great. We are going to be covering all of these topics in our webinar today. But if we break down into some of the more individual topics, what are my work health and safety obligations and compliance tips were high in the votes as well. So you're here at the right place. If you're wanting to hear about any of those things there in the poll. And what we really want to achieve this morning is just content that's really practical, helps you understand not only what the legal requirements are, but how you can actually practically comply with it and what you can implement within your business. So let's get stuck into it. In terms of an agenda, you'll see today we'll be addressing a lot of things that was mentioned there in the poll. So what are the actual legal obligations to prevent sexual harassment? What are some recent law changes, and particularly in Queensland? We'll define what sexual harassment is and provide some examples. And then we'll spend a good amount of time considering how we actually prevent sexual harassment. So again, some practical steps and tips for you. And we'll finish off with a time of Q&A. So let's kick off. Let's start by understanding an employer's legal obligations in preventing sexual harassment. So all jurisdictions in Australia prohibit this conduct in the workplace, with some of these provisions being at the state level, like the various work health and safety laws, and others being at the federal level, such as the Sex Discrimination Act and the Fair Work Act. So I'll hand it over to Ellie now to address each of these laws and some recent changes.
Thanks so much, Dickson. We'll start with the business's duties with respect to work health and safety. Under each state's WHS legislation, a person conducting a business or undertaking, which is commonly referred to as a PCBU, has certain obligations to prevent harassment in the workplace. Obligations under each state's laws are broadly standardised, with the exception of Victoria, which we would note still imposes quite similar obligations. A PCBU covers any kind of business and includes sole traders, companies, partnerships, or any other type of organisation. The broad obligation on PCBUs is that they must ensure, so far as is reasonably practicable, workers and other persons are not exposed to risks to their psychological or physical health and safety. This includes risks from psychosocial hazards such as sexual harassment. A PCBU must eliminate health and safety risks at work, or if that is not reasonably practicable, minimise these risks so far as is possible. A range of other duties apply to managing the risk of sexual harassment, such as duties for consultation with workers and the duties of officers, workers, and other persons in the workplace. These duties are notably broad and are intended to cover the multitude of risks that can arise in the workplace, including those risks to workers' mental health. Where employers are found to have breached their WHS obligations, state regulators may impose fines or improvement notices, or otherwise commence legal action against any duty holder, where serious breaches can even result in imprisonment. Alongside these WHS duties, the Commonwealth Sex Discrimination Act, or we'll refer to it as the SDA throughout this presentation, also includes a positive duty to prevent harassment and other unlawful conduct. PCBUs must take reasonable and proportionate measures to eliminate, as far as possible, certain discriminatory conduct that is unlawful under the SDA, including, as we've already mentioned, sexual harassment and sex-based harassment in connection with work, as well as other conduct related to sex discrimination and victimization. A PCBU's duties extend to eliminating such unlawful conduct carried out by workers, the PCBU's agents, and in some circumstances, third parties such as customers, clients, or suppliers. When determining whether reasonable and proportionate measures have been taken, the SDA requires that certain considerations be taken into account, including the size, nature, and circumstances of the PCBU, the PCBU's resources, whether financial or otherwise, the practicability and the cost of measures to eliminate the conduct, and any other relevant matter. Once again, this creates a positive obligation on employers, meaning that a reactive approach to dealing with complaints is not going to be sufficient to discharge the business's duties. It is also important to note that where the SDA is contravened, an employer will be vicariously liable where their employee engages in this conduct and they have not taken reasonable steps to prevent it. A breach of the SDA may result in civil penalties for an employer and any involved individuals, in order for the employer to make payment of damages to the victim, and particular breaches with respect to the victimization of complainants can result in imprisonment. Beyond a business's WHS duties and the SDA, the Fair Work Act was also amended in 2023 to prohibit sexual harassment in connection with work, including in the workplace. These changes expanded the previous protections around prohibiting workplace discrimination and, like the SDA, provide that an employer will be vicariously liable for the actions of their employees if they have not taken reasonable steps to prevent the related conduct. Most recently, WHS legislation in Queensland was amended such that as of the 1st of March 2025, businesses of all sizes are required to prepare and implement a written sexual harassment prevention plan. The prevention plan must include a description of each risk to health or safety from sexual harassment or gender-based harassment that has been identified in the business, identification of the control measures implemented to address the identified risks, and information regarding how these controls are appropriate in the circumstances. It must include a description of any consultation process undergone with workers in deciding what are the appropriate control measures to be implemented. And it also needs to include a detailed description of the proper procedure for reporting sexual harassment or gender-based harassment. Importantly, the prevention plan must be made readily available to employees, and it needs to be easily understood by your employees as well. Where an employer does not have a prevention plan in place, the state regulator may impose infringement notices or improvement notices. Further, a failure to implement a prevention plan would impact the employer's ability to argue it took reasonably practicable steps to prevent sexual harassment in the case of a dispute, and the employer may face more significant penalties as a result of the breach. This amendment supports obligations under the SDA and the Fair Work Act and goes further with respect to the role of employers in preventing sexual harassment in the workplace. Ultimately, the various amendments to the law show that a reactive approach from employers is no longer going to be acceptable to show that they have discharged their obligations. So I'll now pass you back to Dickson to outline the definition of sexual harassment and provide us with some examples.
Right, thanks, Ellie. That's really helpful. So we now move to the definition of sexual harassment, which is any unwelcome sexual advance, an unwelcome request for sexual favors, or any other unwelcome conduct of a sexual nature, which makes a person feel offended, humiliated, or intimidated, where a reasonable person would anticipate that reaction in the circumstances. Now, what are some of those circumstances to take into account? Well, they include the age, sex, sexual orientation, relationship status, religious belief, and the race of the person harassed. The circumstances also include the relationship between the person harassed and the person who made the advance or the request or who engaged in the conduct, as well as any disability of the person harassed. Now, sexual harassment can be a one-off incident, or it could be repeated behavior. And examples of sexual harassment include inappropriate physical conduct, intrusive questions about a person's private life or physical appearance, sexually suggestive comments or jokes that offend or intimidate, sexually explicit pictures, posters, or gifts, as well as sexual gestures, indecent exposure, or inappropriate display of the body. It's worth noting that the intention of the alleged harasser is not so relevant here. So the conduct may be sexual in nature, even if the alleged harasser has no sexual interest in the person harassed or is not aware that they're acting in a sexual way. And a recent case in Victoria illustrates what conduct can constitute sexual harassment, as well as the risk of penalties for employers. So in March 2025, a painting company was fined $90,000 after being found guilty of failing to provide a workplace that was safe and without risks to health. And so that was under work health and safety, or occupational health and safety laws. And the court heard that the inappropriate behavior began from the worker's first trial shift back in May 2022, when the company's manager, who was also the husband of the company's sole director, made some comments about the worker's appearance and asked intrusive personal questions. Now, this behavior continued and escalated to repeated requests to spend time together, and an incident where the manager put his arm around the worker's neck before smiling and walking away. A little bit later in July 2022, the manager picked the worker up from a train station on the pretense that they had a job in the area. But instead, he drove the worker around for more than 1.5 hours, pressuring them to spend the day with him. The worker resigned following this incident and continues to suffer flashbacks and disturbed sleep while being treated for depression and anxiety. Now, following a complaint to WorkSafe, the regulator, an investigation found that the worker had been subjected to about 60 days of harassment from when they started with the company until they quit, and that the company had no sexual harassment policy in place. And so the court found it was reasonably practicable for the company to devise and implement a policy on appropriate and inappropriate workplace behavior, including sexual harassment, that provided a reporting and response process for workers and training to managers, supervisors, and workers. So now that we understand what sexual harassment is, we'll turn to some strategies and recommendations to prevent it from happening in your workplace. And so the human rights Commission, or the Australian Human Rights Commission, I should say, or the AHRC, which is one of the relevant regulators in this area, has developed a framework of 7 standards for workplaces to address sexual harassment, from prevention to response. And so we thought this is a great place to start for addressing this conduct as an employer. So I'll start by running through what those standards include. The first standard is leadership, which is concerned with ensuring leaders are visible and proactive in their efforts to address these matters, to challenge inappropriate conduct, to promote positive behavior in the workplace, and are transparent and realistic about any risks in the organization. The next standard is culture. So the culture of an organization is another critical factor that determines how it addresses unlawful conduct. Ultimately, every business is reliant on its workers feeling safe and secure to raise concerns or complaints in relation to inappropriate workplace conduct. A business can have all the correct documentation in place, but if people don't feel comfortable to speak up, it's likely that inappropriate conduct will be missed. And so some practical ways to support a positive workplace culture could be to hold regular team building events and ensure proper access to senior leaders. Another standard is knowledge, which relates to workplace education and training on understanding sexual harassment and how to prevent and respond to it. Now, ongoing workplace training demonstrates an employer's commitment to addressing harassment, but also assists in ensuring all employees understand their obligations and feel confident to raise concerns about behavior that they know is inappropriate. The fourth standard is risk management. And so a risk management process involves a few steps that you take, and then you can take again in the future. Now, what it involves is firstly identifying hazards. In other words, finding out what could cause harm. In the context of sexual harassment, there are lots of different methods and ways you can try to identify hazards. Some examples here could be to consult with your workers, would be to try and collect and review data and information, to consider work tasks and the design of work, to look at the physical work environment, as well as observe and consider work behaviors. Consider your workforce structure, and as well as we've talked about a lot, having a reporting mechanism and actually encouraging reporting as well. Once you've identified hazards and risks, the next step of the process is to assess those risks. And that's really about trying to understand the nature of the harm that the hazard could cause, how serious the harm could be, as well as the likelihood of it happening. Once you've assessed the risks, the next step in the risk management process is to actually consider how to control the risks. And that's about implementing effective control measures that are reasonably practicable in the circumstances and ensure they remain effective over time. How we try and do that is the final step of the process, which is to maintain and review control measures. And that's to ensure that they are effective, that they are being used correctly, working as planned, and where changes are required, that they're being made as well. So they're the first 4 standards that are recommended by the AHRC. I'll now hand it back over to Ellie to cover the rest of the standards, as well as give you some practical tips for compliance.
Thanks so much, Dickson. We'll continue with the rest of those standards. So the next one we have is support, which is concerned with employers ensuring appropriate support is available to all of its employees, including its leaders and managers who experience, witness, or receive reports regarding relevant unlawful conduct. As part of this standard, employees should be informed about the available support channels and how to access them, regardless of whether they intend to report the conduct. And this would include access to the company EAP or any other internal support programs that are available to employees. The next standard we have is reporting and response, which involves ensuring appropriate options for reporting and responding to unlawful conduct are provided and regularly communicated to employees and any other impacted individuals. Setting up effective processes for reporting and responding to relevant unlawful conduct demonstrates that the conduct is not acceptable to an organisation. Further, effective processes that are applied consistently build trust in the reporting process, which in turn can help to prevent relevant unlawful conduct from occurring in the first place. We then have the final standard, which is monitoring, evaluation, and transparency. To meet this standard of the framework, we recommend that an organisation should collect relevant data to understand the nature and extent of harassment that is currently occurring within the organisation, and then use that data to assess and improve the work culture, as well as to develop strategies for preventing and responding to harassment in future. This standard also requires transparency from employers about the nature and extent of reported behaviours that could constitute relevant unlawful conduct concerning their workers and the actions that will be taken by the business to address those risks. So now that we've explained the 7 standards as suggested by the AHRC, we can get into our key takeaways and provide some practical guidance for the action items that you can take away from today's session to implement in your specific workplace. Notably, what is going to be considered reasonable and proportionate for any individual business will depend on factors such as the size, sophistication, and nature of the industry it operates in. But there are some steps that almost all businesses are able to and should in fact take. As with any risk in the workplace, it is important to properly assess and identify circumstances which may lead to a higher risk and develop policies and procedures to address those risks. These risks may include things such as a lack of diversity in the workplace, gender divisions, overly hierarchical structures, or the consumption of alcohol in the workplace. At a minimum, a business should ensure that it has the appropriate policies in place to prevent sexual harassment. From a compliance perspective, we always recommend that there are a few different policies that all businesses should have in place. So the first one of those policies would be an anti-discrimination, harassment, and bullying policy, which should describe what those behaviours actually are and expressly prohibit them in the workplace. This policy can also explain the method by which an employee should raise any grievance in relation to an alleged breach of the policy. We would also recommend that a business implement an equal employment opportunity policy, which should address the company's commitment to ensuring that all employees are given equal access to training, promotion opportunities, or any other employment-related issue without regard to any factor other than their competency and their ability to perform their duties. And then finally, we recommend that all businesses have a WHS policy in place, which should identify and address any specific risks to WHS in the relevant workplace. So this might be where employees are working at client sites or dealing with customers directly, and how they can manage related risks in that regard. So beyond having the appropriate policies and written documentation in place, businesses should ensure that they provide appropriate training and education to their employees. This assists in illustrating that the business has a zero tolerance policy and should also encourage employees who witness or experience inappropriate behaviour to speak up. This step also assists in meeting the business's positive obligation to take active steps to prevent sexual harassment, which policies or any other written documentation alone is unlikely to achieve. The training implemented by the business should be mandatory for all new and existing workers. It should be part of a broader commitment to cultural change, gender equality, and diversity and inclusion. It should be demonstrated as necessary by leaders through what they say and how they act. And it should also focus on developing your employees' behavioural skills. Employers should also consult with employees in relation to these matters. We recommend utilising mechanisms such as anonymous engagement surveys, which will assist with identifying any shortcomings in the culture of your workplace in relation to sexual harassment. Finally, it's vital that businesses continue to stay up to date on any new obligations imposed and continue to monitor the various mechanisms it has in place to prevent inappropriate workplace conduct. The most recent amendments to WHS obligations in Queensland are an excellent example of the need to stay up to date with your obligations. And importantly, WorkSafe Queensland has issued a prevention plan template and a completed example for businesses to use as a resource. Other helpful resources can be found on Safe Work Australia's website, including guides and codes of practice, which can provide industry-specific guidance. So that concludes the main part of our webinar today. You might find our employer positive duties fact sheet useful, which can be downloaded from the slide on the screen at the moment. You might also be interested in joining our upcoming webinar, AI, Data and Automation, Legal Risks and Technical Solutions, which will be held on Thursday, the 12th of June at 11 a.m. So we're going to get into your questions shortly, but just while we give you some time to submit them, we wanted to take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. Our team can assist you with unlimited document drafting and reviewing, including those workplace policies that we were discussing earlier. You would also get access to unlimited legal advice consultations and unlimited domestic trademark registration, as well as many other services. We also offer a dedicated service for in-house teams and general counsel to manage your high-volume business as usual legal tasks. If you would like to learn more about the LegalVision membership and how it can assist your business, you can request a free consultation when the survey at the end of this webinar appears. So now we'll move on to some of your questions. Dickson, we might start with this one I can see. So if an employee has reported a sexual harassment experience, but is reluctant to disclose details of the incident and doesn't wish the matter to be investigated, how far does the employer's duty go from there?
Yeah, thanks, Ellie, and thanks whoever submitted this question. I think the first thing to say before we dive into some of these questions is a lot of the answers are going to be really specific to the circumstance, to what's actually happened, what's being alleged. And so I'll try my best to give some maybe more high-level guidance and overview of how to approach this. But just want to acknowledge that each situation can be a little bit different, and so therefore how you respond can be a little bit different as well. And also there's nuance and sensitivity in an area like this. But where we have an employee who's reported sexual harassment, but is reluctant to disclose the details, doesn't really want it to be investigated, that's unfortunately probably not uncommon. It might be in a scenario where, say, it relates to their manager, and they might not want to affect the relationship with their manager if it's reported and maybe made a big deal out of. So the first thing I'd say here is when it comes to being made aware of a risk to health and safety, if I use an analogy here, it would be like if you were told that there was a water leak and a puddle of water in the kitchen that people might slip over. And even if the person who told you, hey, I'm just letting you know, but you don't need to do anything about it, the fact that you are now aware of that risk, if you actually don't do anything about it, don't take any action, you're very likely in breach of your obligation. So coming back to what we discussed towards the beginning around employers needing to take reasonable steps to ensure the health and safety of their workers, if we actually don't take any action relating to a risk we've now been made aware of, then again, we're very likely not have complied with the obligation. So in short, if we've been put on notice and we can't do nothing despite the person reporting, saying that that's their preference. So we're going to need to do something, but we can still do it in a delicate way. So for example, if that could mean a subtle change in a reporting line, that could be a way to actually address the risk that's been raised. But ultimately, what steps you take, what's sensible in the circumstances, again, will just depend on, what's actually been raised. And again, ultimately, the thing to remember here is you need to be taking reasonable steps. You need to be proactive in all of this. And so you can't really do nothing if you've been made aware of it. So yeah, we can't say, oh, the person told us they didn't want to be investigated, so we've done nothing. It'll be like that, pool of water in the kitchen that someone does slip on in the future. Yeah, we can't get away from that duty.
Great. Thanks, Dickson. We've had another one come through. So when workplace behavior falls into the quote unquote grey area, it clearly doesn't breach legal obligations or the definition of sexual harassment, but still causes discomfort or tension, especially in multi-generational teams. What is the best method of legally protecting the interests of the business?
Yeah, great question. So I think with this one, we again come back to what are the reasonably practicable steps and measures that we can take here. So even if there is conduct that maybe doesn't quite meet the definition of sexual harassment or discrimination or bullying in the workplace, they could still be, it still could be conduct and behavior that raises risk hazard to the health and safety of your workers. And so we're applying all the same principles and recommendations that we've talked about in our presentation in terms of, well, identifying those risks, assessing them, and considering any control measures that need to be implemented. Now, again, part of this could involve consulting with workers, training workers as well, and ultimately, even if it doesn't quite fall into a category of, say, sexual harassment, you as an employer are still allowed to warn people about their conduct and inform them what's appropriate, what's inappropriate, what's expected of them in the workplace as well. Again, appreciate that this can be a bit of a delicate issue and depends on what that behavior actually is as well. But yeah, keep in mind that you need to be doing something here, particularly if you've been made aware of it. And so, yeah, consider it, document it, figure out what you can implement in your workplace.
Absolutely. We have a question here that's quite similar to the first one, but a little different. The question is, what if the staff member who experienced the sexual harassment is not the one putting in the complaint and did not necessarily want that complaint to be made? Is there any differences in the response there versus the first question?
Yeah, I'd say it's pretty similar to my answer to the first question, which is you again come back to even though they may not want the complaint to be made, in a sense, what we are worried and concerned about now is the fact that we are aware of this risk. And so again, if we do nothing about it, then the business is at risk of not complying with its obligations. And so again, it's just important here that, again, while we want to treat it sensibly, delicately, as relevant, you need to be taking action in the circumstances.
Yeah, absolutely. Thanks, Dickson. So another one here. Are there similar laws/requirements in all of the states and territories throughout Australia? And how do businesses that are nationwide affect these changes? Because normally policies would be implemented company-wide.
Yeah, absolutely. So as we mentioned towards the beginning of our presentation, the laws here, there are a few different pieces of law that address and prohibit this kind of behavior in the workplace. And so that's both at the state level. So we're thinking work health and safety or occupational health and safety if you're in Victoria, and then the federal level as well, the SDA and the Fair Work Act. And so, yes, these requirements, these obligations are all exist and all quite similar across Australia. Of course, particularly say with the work health and safety side of things, there are going to be some specific obligations and requirements. So the easy example here being the one we touched on in Queensland with the written prevention plan in relation to sexual harassment. So yeah, that's something you're going to need to be aware of, that there are going to be some differences from state to state. there as well. But from the policy perspective, I think it is okay to have a company-wide policy on work health and safety, on anti-discrimination, bullying and harassment, for example. I think that's okay. But you also just need to be aware practically how you deal with some of these differences in the laws firstly. So for example, if you're in Queensland, to make sure you have that written prevention plan, and that could be separate to the policy. But then also you almost just have to think about it from the perspective of each particular, say, workplace that you have as well. So maybe in New South Wales, you've got office-based workers, and so there'll be risks that are maybe more specific and relevant to that office space, and the types of workers and the work that they perform there. And maybe in a different state, you've got people working in a warehouse. And there could be different risks associated with the warehouse as well. So in one sense that, yes, there are overarching requirements and obligations to comply with, but practically, if you're operating in multiple states or territories, you're just going to need to consider, in a more specific, say, for example, workplace level as well.
Yeah, absolutely. We have another one here where the viewer first notes that even where reports of sexual harassment haven't been made, there are obviously still obligations in place for employers, and basically wants to understand what are the best practice recommendations for monitoring and evaluating risks to workers' health and safety in the workplace.
Yeah, so in one sense, that's hopefully a good position to be in if you've never received any reports or complaints around sexual harassment. But as we've talked about, and as whoever's asked this question clearly understands as well, it's about a proactive approach here. It's not enough to just be reactive to complaints or reports that are made. And so firstly, just wanted to echo all the practical steps that Ellie mentioned towards the end of the presentation. And so much of this, there are so many ideas and methods for identifying, monitoring and evaluating. And so, yes, these could be reporting tools, these could be anonymous surveys, these could be walking around and trying to observe behavior as well. But actually, it's a good idea to have as much of a paper trail and documentation as possible for what steps that you have taken. Because ultimately, if you are ever challenged, if there's a dispute or if there's an inspection by a regulator of your workplace and what you've done, what steps you've taken, having that documentation around the risk assessments you've undertaken, around the tools that you've used as well, will go a long way to helping you to show and evidence that you've taken those reasonable steps. And again, in terms of, I think part of this question is around training modules and resources as well. There's really a lot available for free. And so there are, I believe, training modules and resources on the AHRC website. There's an entire guide on this topic, and we really only summarized it very briefly. Even with the standards that we talked about, it goes into a lot more detail and provides a lot of practical recommendations as well. And I believe there are some online modules that are and training modules that are available too. If there's something you'd like some legal assistance with, we have a work health and safety advisory service here at LegalVision. Part of that service involves some training that we've recorded and that we provide to you so that you can give to your workers and to your managers as well to help educate them on these issues. And so, yeah, that can be something we can help you with if that's what you're interested in as well.
Fantastic. Thank you, Dickson. So we have one more question here with regard to a contracting scenario. And essentially the question is, to what extent does a principal contractor need to educate engaged subcontractors?
Yeah, another good question, and highlights a good point, which is in the context of work health and safety. There can be multiple duty holders, even say in the one workplace. And so there are lots of duty holders, people involved, from the business, from its managers to its workers. And yeah, sometimes there are other parties that have some sort of control or management over the workplace as well. And so in the context of contractors and subcontractors, the way I'd start thinking about this is, yes, you still have obligations. Even so, say you are the principal and you are engaging a contractor, you still need to consider your obligations here, but it comes back to reasonable steps. So what reasonable steps can you be taking to ensure the health and safety of your contractors? And if they engage subcontractors as well, that are maybe on your site, then yes, that's still relevant too. Now, whether that goes as far as you needing to directly educate them, possibly not. But ideas and considerations here could be whether you include in any contracts with your contractors something related to work health and safety, some obligations that you want to put on them to educate their subcontractors or to ensure that people who work with them are properly inducted and are complying with their obligations as well. Again, this is all very specific to the business, to the arrangement, to the workplace as well. But yeah, there are times where it could be appropriate where, say, you have management and control over a site and people are coming to it. Maybe you actually need to be involved in that induction around, how to perform work safely, both from a physical and a non-physical sense as well. So again, we come back to that principle of taking reasonable steps. You need to be doing something, but only so far as reasonably practicable. So yeah, consider the specific circumstances. The more that is in your control, the more that you can actually do there. But yeah, see if you can place some obligations on your contractors as well, and potentially keep an eye out on what's happening on site too. All right. If there are no other questions, I hope we've been able to answer the questions that you've asked. We might wrap up there and finish up. So just a quick reminder that there's a survey coming up very shortly. And again, we'd love to hear your feedback, things that you found helpful, things that could have been improved as well from the presentation. Time filling out that survey. That survey is also an opportunity for you to fill out your details and learn more about how our membership can assist you and your business as well. So thank you very much for joining us. And yeah, we hope you have a great rest of your day.